So I'm going to study some U.S. case law. This is going to be a lot of fun. We're going to talk about Kalina v. Fletcher, 1997. We're going to talk about Allen v. McCurry. We're going to talk about Scheuer v. Rhodes, 1974. Morales v. Waco, and so much more. So without further ado, let's go with Morales v. Waco. Morales v. Waco, 1991. This is, Dred Scott. I don't want to always use Dred Scott decision because that's like just a terrible, awful, the worst decision ever. That's a decision that's going to cause a goddamn civil war. Morales v. Waco, the judge is absolutely immune for ordering Raymond Morales, a defense lawyer, to be arrested via bench warrant, and even ordered the cops to rough him up a bit to teach him not to skip court dates. The lawyer was in the courthouse at a different hearing. The cops forcibly, with excessive force, arrested him, throw him through the double doors. So I want to say that Raymond Morales is the judge and Howard Waco is the lawyer. This happened in Van Nuys, California. Stevens dissented strongly. Scalia and Kennedy dissented weakly. So Scalia dissented. That is very important if you're like, well, according to Morales v. Waco, because this is saying that judges could do excessive force. Cops can't do excessive force. But if the judge orders you to do excessive force, then you're allowed to break the Fourth Amendment. There was another case where the judge had signed off on the damn warrant, but the cop was supposed to know that the warrant wasn't good enough. He was supposed to know that. So that means even if a magistrate or a judge signs off on your warrant and you're a police officer and the warrant is no good, then the responsibility is going to fall upon you, the police officer. So that's a lot for just a lay cop to know, because it's like, well, the judge knew, the judge did the thing, and the magistrate, they signed off on it. So was he acting in his judicial capacity? For absolute immunity, he's got to be doing something non-judicial or outside his jurisdiction, right? He violently seized, I want to say it was the public defender, a defense lawyer, violently seized him in court, pulled him backwards, cursed him with vulgar and offensive names. You dirty, rotten scoundrel, you dirty rat, you dirty rat. Slammed him through the doors to Raymond Morales' courtroom. So Raymond Morales is like, where the hell is that damn? It's a lawyer too. A lawyer is an officer of the court. And then when it comes to a lawyer versus a cop, don't lawyers have more? And then what was the crime? If he's in another courtroom, then that means he was at a hearing. He has other clients. So when he goes into that courtroom for an arrest, could that first courtroom order the arrest for him to get back there? And so they just have these competing cop arrests going back and forth. Haynes v. Kerner, 1972, says that the pro se complaint shouldn't be dismissed without having a chance to show some evidence on the claims. How are you going to dismiss a damn claim when you don't even know if any evidence can support the thing? If the person was like, well, they did excessive force on me, dismissed, it's just an allegation. Can I at least show some evidence? Can I at least attempt to show some evidence that there is excessive force? No, you may not. But Morales v. Waco, it's like they don't even care if there's evidence of force. I got this book saying that they just make it up as they go along, which is terrifying. I'm kind of mortified. It's like, is America not the way that I thought it was supposed to be? I thought we had the freedom of speech and the right to peacefully assemble. We all knew this, we're all Americans. So since we're all Americans and we're doing this American thing, then we all know that we all could just talk a bunch of shit, and that's just the way it is. Now, Forrester v. White. Forrester v. White, 1988. This is Howard Lee White, who's a circuit judge. White is going to hire and fire a probation officer. Fired Cynthia A. Forrester. So he does this sexist thing, right? Forrester v. White is another absolute immunity case for the judge, but this time he doesn't get absolute immunity. Why? He fired a probation officer, and they said he did it for sexist reasons. So he discriminated against a probation officer for being a female. Now, the reason why they said he wasn't absolutely immune was because a truly judicial act has got to be separate from the executive, and it's got to be separate from the legislative, and it's got to be set from, it's got to be different. It's got to be different between the executive, legislator, and investigation and administration. So judges can't do any kind of administration. They can't do any kind of administration. The judicial branch needs administration. Forrester v. White is a terrible decision. I feel like they like Cynthia White, so they're like, you know what? You do. Maybe she had a good lawyer. I like this lawyer. He's making a lot of really good cases here. So therefore, judges have absolute immunity for so many things. Absolute immunity as long as it's within their official duties, as long as it's a judicial act. So a probate judge can't run a criminal court. But here Forrester v. White says that administrative acts aren't protected by the absolute immunity of judges. Sometimes these exceptions are so stupid. I'm against absolute immunity. I'm against absolute immunity. And then I'm wondering about this whole case. Like, did she actually get fired for being a woman? Because, that seems crazy to me. I'm going to fire that probation officer. Why? Because she's a woman. Because she's got an ass, tits, and a vagina. She's a softer version of man. That's just not good enough for me. Briscoe v. LaHue, 1983. The facts don't suggest perjury happened. Perjury alone are insufficient to state a constitutional claim. LaHue had not testified under the color of law. Briscoe's claim was collaterally estopped by conviction. Briscoe v. LaHue. I think that's another stupid-ass case. Briscoe v. LaHue, 1983, says that cops are allowed to lie. He's allowed to lie, but isn't perjury? Perjury could get you 6 years in jail if you're like a regular citizen and the lawyer and the judge, they push for it. But if you're a police officer, you're allowed to get on the stand and just say, yep, that's the person who was doing the raping. I saw him doing all the raping. And boy, did he really rape. He raped so many people. I saw him, and we all saw him, and we got videotape, we got notes, we got so much evidence of him raping. Immune. He gets immune. He gets immunity for perjury. That's incredible. Tenney v. Brandhove, 1951. Tenney v. Brandhove, 1951. Legislators get absolute immunity. So that's what started it all, right? In some respects, a legislator, what are they doing? Just writing the laws, unless they write a law like, some clear discrimination. Anybody can just write the law. It's really about how the laws get enforced. So the legislators, I guess there's some, if they write just a terrible damn law, just saying all brown-eyed people are going to get thrown into the gulags, then they shouldn't get absolute immunity. But it's almost like a legislator. They just kind of go there. They write some laws. They should be a moral leader. They should give good speeches. And then they should kind of relay what the law currently is and what the law is that they're trying to change. Because the only power legislators have is to either keep the laws or to change it, right? You have temporary laws and permanent laws. And they can change all those things or keep it all the same. A few facts. Citizen was passing a flyer around the Capitol and the legislators got mad. They tried to initiate some charges. So this is like a citizen is at the legislature and he's passing a flyer around saying these people are corrupt. The legislators get mad. They try to initiate these charges. And then it's like, hey, they're immune. Hey, they're immune. Hey, what can I say? They're immune. Conley v. Gibson, 1957. The complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of their claim. So this goes along with that other case we just stated, right? Haynes v. Kerner. Pro se complaint shouldn't be dismissed without having a chance to show evidence on the claims. Conley v. Gibson, 1957. The complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of their claim. So that's the only way you get dismissal. That comes from Twombly, 2007 Twombly, Ashcroft v. Iqbal, 2009, and Haynes v. Kerner, 1972. And then I start to write Bell v. something. So there's another case out there, Bell v. something. Hartman v. Moore, 2006. Hartman v. Moore says that you must allege and prove that the criminal charges were brought without probable cause. And the facts behind Hartman v. Moore, 2006, is the U.S. Postal Service, William G. Moore, CEO of Recognition Equipment Incorporated, REI, was a 5-2 ruling. They said that they had to prove that the prosecution was retaliatory. You say it's retaliatory, now prove it. Well, they said, if you fuck with me, I'll goddamn prosecute the shit out of you. Even over some dumb shit. I got it on tape. That's what she said. She says, I'm going to prosecute you over some dumb shit. Because fuck you. March 14th, 17th, and the 18th. These were due dates. So that was due freaking 3 months ago. That shit was due 3 months ago. So we already got, let's see, Shower v. Rhodes, right? Should we try to figure out how to say this shower? How do you pronounce shower? It's spelled S-C-H-E-U-E-R. S-C-H-E-U-E-R. And the way you pronounce it, to me, seems like showers. Sure. Like shoe or what? Sure foot. A shoe or glove. Those are the only things you get. You either get a shoe or you get a glove. Okay, so Schuer v. Rhodes, 1974. This is a good one. Pay attention, America. When considering a motion to dismiss, the facts and inferences come from the plaintiff's amended complaint and are viewed in the light most favorable to the plaintiff. When considering a motion to dismiss, the facts and inferences come from the plaintiff's amended complaint and are viewed in the light most favorable to the plaintiff. Well, my God, when you combine all these things together, Conley v. Gibson, Twombly, Iqbal, Haynes v. Kerner, you can't dismiss it unless they have a chance to show some evidence, because the whole idea is this even conceivable? Is it even conceivable that the person that they had accused of doing A, B, and C, is it even possible that he could have, that Cruz Soto could have broke the Sixth Amendment? Is it even possible that Cruz Soto didn't have a warrant to begin with, and he just went along with this liar's lie in order to do prosecution, to do a malicious and corrupt thing? Is it even possible that a police officer could break a Bill of Rights? Can the police officer ignore your Second Amendment and your Fourth Amendment, and in a way kind of your Third Amendment and your First Amendment rights too? Because, 3 warning shots, which injures nobody, yeah, it's kind of a Second Amendment case, but it's kind of a First Amendment case too, isn't it? I mean, that's a strong remonstrance. You're communicating with somebody. If money could be speech, then why couldn't gunshots? The only thing gunshots do is just make a loud pop, right? We're allowed to light off fireworks. And then because I said that I was, firing warning shots, hell, if they would have actually, I could have lied about the damn thing, right? I could have just been like, no, I was just doing, I was just doing some target practice. No, I was just doing some target practice out in my backyard. That's all I was doing. It's incredible how liars get away with their shit, but the people who tell the truth get screwed over. Just like in Framed. What was it, that Hasty Mark murder? This Shearer v. Rhodes is even more interesting because it has to do with the Kent State Massacre. What was the Kent State Massacre? Well, the students didn't like the Vietnam War, and so the National Guard went to Kent State University in Ohio in 1970 and shot and killed 4 students. How dare you protest against Vietnam? And so that's scary as hell. Our own damn military is shooting us dead. We have a right to peacefully assemble. That's the First Amendment. So when you consider a motion to dismiss, the facts and inferences come from the plaintiff's amended complaint and are viewed in the light most favorable to the plaintiff. Is it possible that a police officer arrested somebody in retaliation and then they didn't go to the court? They didn't go to the court in order to testify? That's not even possible. No, it's not only is it possible, not only is it probable, it actually happened. So to ask the question, is it even conceivable? Yeah, it is very conceivable. The question is not if the facts of the plaintiff are true or not, but whether the plaintiff is entitled to offer evidence to the claims. So when it comes to a motion to dismiss, that is a very limited scope. The question is not if the facts of the plaintiff are true or not, but whether the plaintiff is entitled to offer evidence to the claims. If there's no doubt that none of the claims can be proved to dismissed, then the dismissal must be dismissed. You must quash the dismissal. That comes from Conley v. Gibson. We're mentioning Conley v. Gibson again, and we're also referencing Gardner. Gardner v. Toilet Goods, 1967. I pretty much governed my entire life on the American common law of Gardner v. Toilet Goods. If I want to just do some gardening, why does Toilet Goods want to stop me from doing some gardening? Bad Elk v. U.S. 1900. An individual can resist a wrongful arrest. That was Bad Elk v. U.S. 1900. Ex parte Merriman 1861. Habeas corpus, an unlawful detention. Sometimes you just got to throw that crap in the garbage. Hep Tuitt v. U.S. 1871. Military arrested natives on the reservation. What the hell is going on with that? Hep Tuitt. When it comes to the Dred Scott decision, that was a terrible decision, right? The Taney court, Taney fucked up. Curtis and McLean had dissented. So who looks like, the geniuses now today? Dred Scott was an embarrassing backwards decision. But because Curtis and McLean not only dissented, but they eloquently dissented, what are you doing? Like, what the hell are you doing? Dred Scott has been an American the entire time. He was born here. He went from one state to another state, went to this owner to that owner. When the hell does he get his freedom if you're basically saying that there's no you're just you're saying slavery is okay, you Roger Taney son of a bitch. So Curtis and McLean had dissented. So that's important because if you have a Dred Scott decision, if you have a decision that's terrible, the dissent is going to, is going to be the ruling opinion. It's going to be the leading opinion. And there's a bunch of Dred Scott decisions that we've come through. Stump v. Sparkman. Holy fuck, does that piss me off. Remember what happened with Stump v. Sparkman? Stump v. Sparkman is this mother that gets her daughter sterilized against her will. She tricks her saying that she's going to get an appendicitis. She's going to get her appendix taken out, takes her to the doctor. 3 doctors go ahead and sterilize her because the mother had put a petition in front of a judge, and the judge fucking signed it. They didn't even ask the daughter if she wanted to. They didn't even tell her that it was happening. She just trusted that her mother had her best interest in mind. Her mother totally tricked her. And then later on, when the daughter is married and trying to have children and she can't have children, she's told that her tubes were tied. Well, how'd that happen? Well, you remember that appendicitis? Yeah, I was actually... And then why did they tie her tubes? Because her mother said that she was, essentially like a whore in training. Your Honor, my daughter is a whore in training. Can you just tie her tubes before something bad happens? Just tie her tubes. Something bad is about to happen. She's about to get pregnant? Is that what you're saying? That's the bad thing? Yes. Something bad. And then he was fucking exonerated. The judge in that outfit was like, hey, he's absolutely immune. He's the one that signed the petition. If the judge didn't sign the petition, then the daughter doesn't get her tubes tied. Morales v. Waco. The judge says, hey, arrest that defense lawyer. He's in another courtroom, and I want him in this courtroom. He's supposed to be here on time. And then the cop just manhandle. Make sure you do excessive force. I mean, the excessive force thing is really the kick in the nuts for me. Because are you even allowed to arrest a defense attorney when he's in another courtroom? Like, talk about not having any fucking probable cause for that goddamn arrest. The defense attorney is in another courtroom. And so when he's taken out of that courtroom, does that judge, and they just keep arresting each other just back and forth, right? They just keep on playing a tug of war, and they just keep throwing them through the doors, and then the other one just throws them through the doors. He just gets arrested over here, arrested there, and just keeps getting arrested all day long because it's just this big tug of war, this power. And it's a defense attorney. So you know what the judges and prosecutors really hate? Having an educated officer of the court that's in the court giving the defendant, the accused, an actual defense. That's what they really hate. So they already hate the defense attorney. DeShaney v. Winnebago. DeShaney v. Winnebago is another crazy case because the kid was getting abused over and over and over again, and then ultimately the decision was, hey, we can't be held responsible for the shit we don't do. Yeah, we knew the kid was being abused. The hospital knew, the cops knew, the social workers knew. Everybody knew that the kid was being abused. And we didn't do a damn thing to stop it. We wrote a file, we put it in a filing cabinet. What more did you want us to do? Stop the goddamn genocide? Stop the fucking abuse? And then the boy is going to die. DeShaney, poor Joshua. It was a famous dissent. Poor Joshua. Joshua doesn't get any say-so. Nobody protects Joshua. So all these, 3 branches of government and the enumerated powers and the Bill of Rights, he doesn't get the protection of the government. The whole idea of being obedient to the king is like, okay, I'll obey you, king, but I get protection, right? So you obey the king in exchange for protection. If you're not getting protection, then you don't get the obedience. 4-year-old Joshua DeShaney, he gets beat up and he's turned, mentally, physically. They fuck him up. They fuck up him mentally. They fuck him up physically, and he's like an invalid almost, or just with the diminished capacity. I don't want to say the R word, but basically it's the R word. Like he's literally mentally, physically retarded. So his dad beat him until he was mentally and physically retarded. And then he's going to die. I think that's the story. He dies like at 20 or some shit. What the fuck? That's America? That's the American dream? Hey, I came in here to make sure my children had a better life. Not, Daddy DeShaney. Daddy DeShaney was like, hey, I had kids too. That's almost like there was that guy that just killed those kids. Was it Travis Becker or something in Washington? There was that case in Colorado too. But the case in Washington, the guy kills his own kids. He kills his 3 daughters. It's hard to say that somebody could have done more because hindsight is 20/20. But when it comes to the DeShaney v. Winnebago case, it seems like if there's an opportunity to intervene, the state has so much authority. I just saw a cop just arrested a guy for wearing a hoodie sitting outside of his workplace because the cop was thinking that looked suspicious. So cops could just make up shit to arrest people. They could have no pretense whatsoever and just arrest people. But when the kid is being abused and everybody knows about it, Nobody does the arrest. Pearson v. Ray. Oh, Pearson v. Ray, 1967 is another fucked up court case. Pearson v. Ray, this is where the good faith standard, I think it says two things actually. Pearson v. Ray says that you could sue the cops, more Monroe v. Pape, but Pearson v. Ray says that you could sue the cops. I guess Monroe v. Pape was 1961. Pearson v. Ray is 1967. This is a segregation case. This is after the 1964 Civil Rights Act. So Pearson v. Ray, you got 13 black ministers, and this is after segregation was over. After segregation was declared legally, this is a Dred Scott decision. What we get from Pearson v. Ray, there's three court cases. Harlow v. Fitzgerald. Harlow v. Fitzgerald brings in qualified immunity. Pearson v. Ray brings in the good faith defense, and then the functional approach. That isn't Briscoe v. LaHue, is it? I'm not for sure where there's three basically main cases of what cops can claim immunity under. So cops go and arrest these black ministers. I want to say they were in like Tougaloo, Mississippi or some shit. So these 13 black ministers are at a bus stop, and they're allowed to be at the bus stop, but they just weren't allowed to go to the donut shop. So they went to the coffee shop, they were drinking some coffee, eating a donut, and because they were drinking a coffee and eating a donut, they get arrested for a breach of the peace. The police arrested them for breach of the police. The standard for Pearson v. Ray is the good faith standard. And then the lawyer for it goes to the Supreme Court and she's like, well, yeah, we believe that the common law says that they're allowed to do what they did. Oh, the common law says that they're allowed to do what they did. Good faith standard is that the police had good faith, that they were just arresting somebody for breaching the peace. They knew it was a law. They knew that those people were breaking the law. And so they were just doing their job. You got to give them good faith. If they are doing the thing in good faith, if the police arrest somebody in good faith, you have to uphold it. So the objective reasonable. I'm getting this all confused. Harlow v. Fitzgerald does introduce qualified immunity, but I think it brings in the objective reasonable status too. So there's the functional approach, objective reasonableness, and good faith. So those three defenses are real interesting, right? So cop just arrests, 13 black ministers for eating a donut, and they said, hey, we did it in good faith. Yeah, bullshit. You're being a bunch of racist pieces of shit. They could use the functional approach and say, hey, we're cops. We're in very much an important part of the judicial process. And because we're cops and we're a very important part of the process, because of the function, we get immunity. And then there's the reasonable objective standard that just says, if a reasonable person was in that cop's position, would they have came to the same conclusions as that cop? And then Albright v. Oliver. This is another Dred Scott decision. Albright v. Oliver, 1994. This is so insane. So Albright v. Oliver, I want to say the cop is Albright or Oliver, one of them. Veda Moore. Veda Moore is this co-core. The cops had hired a co-core to be an informant. She keeps on lying. She just opens up a telephone book and keeps on pointing different names out. The cop keeps making arrests. And it happened 50 fucking times. 50 fucking times. Like, this is insanity. If you have a police officer who arrested 50 people and all those cases get thrown out of court and dismissed because he had relied on this Veda Moore who's lying, and she's a paid informant, so the cop is paying her essentially to carry on with her coke whore habit. She keeps on giving him false names, false information, and then here in this case, Albright v. Oliver, it even gets more fucked up because she says it was this one guy, and not only did he sell her not cocaine, but he sold her baking soda. What? He sold you baking soda? Well, that's outrageous. And so the cop goes to arrest the father, and the father says, it's not me. They go arrest the son. It wasn't him. And then they arrest the brother. And it's like, what in the hell are you sons of bitches doing? What in the hell are you sons of bitches doing?